So as we've probably seen, because there's been quite a lot of presentations on it today, mental health is definitely a growing and important area of the law, and obviously in general. Currently, the English and Welsh legal system is not equipped to deal with the complexities that mental health presents, especially in respect of sectioned patients and their rights. So what I want to do is I want to start by grasping what everybody's interpretations of sectioning is. So I'm going to put an image on the board, and I want you to tell me what you think. Well, you don't have to tell me, to think to yourself what you think of. Commonly, this image would be linked to someone that's committed a wrong, such as a criminal offence. It's not normal that someone would think of a distressed, vulnerable and ill patient who is in need of help. But unfortunately, this can be the case, because sectioning has been likened to medical imprisonment. A mental health patient that has been sectioned can and will be treated like this. This is important because 1 in 4 people are reported to suffer with a mental illness. Now, I personally believe that this figure is bigger than this. Mental health is a prominent issue within today's society. It is becoming increasingly more accepted, which should mean the law should update itself to this. The Mental Health Act is 36 years old, and at the time of it being written, the concept of mental health was not as accepted by society as it is today. In addition to this, there are over 100,000 hospital admissions per year, and our mental health legislation is not at the stage where it can deal with it effectively. Sectioning is one of the most draconian state powers. To section someone is to deprive them of their right to movement, their right to communication, and most importantly, their right to bodily integrity. The criteria for someone to be sectioned is very loosely applied. To section someone, you have to have a loosely defined mental disorder, and you have to pose a risk. The second element of the sectioning criteria leads to the argument of who sectioning is protecting. Is it in the best interests of the patient, the doctor, or the public? Baroness Hale suggested in her recent book that it is the doctor's decision whether to treat or not, which would suggest that sectioning is essentially protecting the doctor from any liability that may be caused. There have been suggestions, namely following the Wesley report, to strengthen the criteria for sectioning. Whilst this does not show support for increasing the rights of sectioned patients, it demonstrates how policymakers have acknowledged there is an issue. This report also highlighted issues relating to enforced treatment, namely in relation to religious or spiritual practices. This refers to cases including Nottinghamshire Healthcare Trust and RC. Critically here, the clinician wished to respect the patient's Jehovah's Witness statement and did not apply Section 63 of the Mental Health Act to force a blood transfusion. It is detrimental to clarify here that in the context of a blood transfusion, it could have been enforced, and in many instances is, even though the patient may have had that belief for longer than the mental illness. This is a position that cannot be accepted by society. In addition to this, an inflexible interpretation has been given with regards to what falls under medical treatment under Section 63 of the Mental Health Act, which has led to peculiar procedures such as caesarean sections falling into this category. Surely, to coerce someone to have a serious medical procedure against their will cannot be perceived as treating their medical disorder when it is not directly related. Especially in these instances, given it is hard to see how a caesarean section is treatment for a mental condition. There are 2 cases I'd like to draw to your attention. The first one is Tameside and Glossop Acute Services Trust and CH. Here, a woman wanted to refuse a caesarean section but was not given this right. Unfortunately, the law is receiving a reputation for hiding behind sectioning orders to enforce caesarean sections. This is again seen in St George's Trust, where the court abused the patient's once recorded depression to section and compel a caesarean section order. Now, it's important to note here that following an appeal on this case in the Court of Appeal, the judges themselves acknowledged that this should not have happened because the criteria of the mental order presented was not strong enough for a section. Questions must therefore be asked about whether other treatments are falling into the scope of Section 145 of the Mental Health Act. For those of you that aren't aware, Section 145 states that the treatment must be relevant to the Section 63 recorded disorder. It is therefore asked where the line should be drawn. I'm asking you if you think enforced treatment should stretch as far as treating the mental disorder, or whether it should extend to life-threatening conditions. On the slides now is a quote taken from the Mental Health Act Survey Centre for Mental Health, which states that being sectioned was one of the most traumatic experiences of my life. Sadly, as a result of being sectioned, I developed PTSD as a direct result of the way I was treated. This is something highlighted in a report issued to the government. For those of you that aren't aware, PTSD is post-traumatic stress disorder, which is a recognised mental health condition. I think it's really important to look at what this quote says, because it's highlighting how sectioning is not the best for everyone. Whilst it must be acknowledged that in some instances you're going to have to do you're going to have to section people and treat them against their will, it's not always the most appropriate treatment. And other jurisdictions such as Australia have acknowledged this when they've updated their Mental Health Act, and they've introduced community treatment orders as opposed to being sectioned, which removes the stressful environment for some of being in a hospital and not having control. This is something that should be looked at in the UK when they're updating their Mental Health Act and looking at the ways in which treatment is and can be given. In addition to this, there is another option, as known as advanced decision directives. Whilst this is seen in the UK at the moment, it's not given a lot of legal weight, namely because the Act has been around longer than this concept. It's a developing process that allows patients to predetermine what treatment they do and do not want. So essentially, it's like a living will, which I've put on the slides. It's what some academics have described it as. It means that you can, if you're worried about ever being sectioned, you can create a plan to say what you do not and do want. And this is enforced with attorneys, and you can have doctors sign it, which gives it legal weight. Countries such as Australia, America and the Netherlands have all acknowledged the positives of using this. And whilst it can be seen that it puts pressure on doctors, because at the end of the day when someone is sectioned, they normally don't have the mental capacity, so they should be seen as the treatment's in their hands, it shows that the patient as a person is not being forgotten, something that really has been left out of mental health legislation. They're treating the condition and not the person. And that's everything. Thank you.